Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott's Employer Briefing. These monthly briefings address COVID pandemic-related updates and other developments affecting our society, including the Black Lives Matter movement, as well as key judicial, legislative, and policy changes. This briefing will be recorded. Everyone who registers today will be registered for all future employer briefings. I want to address some preliminary items before we begin. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's briefing will address the latest developments affecting employers operating during the COVID pandemic, the newest challenges employees are facing as part of the broad-based focus on discrimination in America, and key legal and federal agency developments. The presenters today are FortneyScott attorneys David Fortney, Elizabeth Bradley, and Bert Fishman. I will now turn the program over to David Fortney to start our briefing.
Valerie, thank you, and greetings, everyone. Great to have everyone back, and particularly Liz and Bert. Nice to see you again as we all continue to work virtually, as I think everyone generally is in the same mode at this point. Well, we've had a lot that's happened in the last 4 weeks since we were last together. Let's hit a couple of the preliminary points so we can dive right into the materials. First, just a notice about ourselves. We, of course, are a Washington, D.C. based law firm. We do focus on the federal agencies with respect to both rulemaking, enforcement, and a host of compliance issues. In fact, the very heart of what we will be discussing today. Our attorneys generally, and certainly those that are participating in today's update, all have very extensive experience in these matters, and regularly, day in and day out, are counseling and advising clients throughout the United States on the issues we are discussing today. Full bios for both Liz and Bert and myself are included with the materials. Let's just jump to the next slide and just note that although obviously we are lawyers and most of what we are discussing today are significant legal developments and updates, the purpose of today is informational, and it's to help you as employers stay on top of these developments. We would encourage you, though, to ensure that you secure legal counsel and advice from your respective counsel, either your in-house counsel or outside counsel, who's experienced in these matters and can provide you with specific information about how these issues fit in your particular circumstances. All righty. Well, let's jump right in and talk briefly about the agenda, which is packed. There are a number of COVID-19 related developments, and many of you have been with us for other briefings. You know, we always take the first segment to talk about what has happened on the COVID related items. In this case, it's primarily within the executive branch, but there have been a number of developments there with respect to the president's responses, both MOUs and executive orders, and in terms of the Labor Department, some developments with respect to the FFCRA regulations that were partially set aside. We're going to walk through that so you have the highlights of that, as well as highlighting some of the new key state law developments, changes, and trends that are particularly important for multi-state employers as they address this area. And obviously then the school openings, very timely topic as we move into late August through beginning of September, and the impact on employers. We'll then pivot right into the Black Lives Matter developments, and there is a spate of very recent issues arising with respect to political and social messaging in the workplace, and how employers can respond in some new maneuvering room that the Labor Board has recognized for employers. Very positive. Then, of course, we want to give you the federal agency, and there are a couple of important updates there. So we've got 60 minutes to do all that. Yeah, that's a tall order.
To do.
And Liz, I'm going to ask you to kick us off, please.
Sure. First, we're going to start with, what has happened since we last met. And on the next slide, going to look at where does the U.S. currently stand with the COVID case map. So it is trending positively down. We are starting to see that drop. Notably, we're still above the peak, the prior peak where we started to come back down before and think some of these restrictions could be lifted and limited. So we're still a pretty high number. And I think a pause point here, as we're going to be talking about, is workplaces are reopening, schools are reopening, campuses are reopening. What is that potentially going to do to these numbers? And this really isn't just because it started to trend down a little. I think that a pause point here and a caution point is just because these numbers are going down, we have a lot going on in both work and school environments that may make this trend back up. And we all should continue to be diligent in our personal lives to help mitigate some of the additional social interaction between work and school that we're going to be seeing.
Exactly. And just as you're looking at that, one thing I'm struck by, you see on the graph, we're just right below 50,000 cases a day nationwide. And of course, it varies greatly depending on where you are, which region. Some spots are very hot, others are not so much. But if you go back and look at where we were in June, which is largely when we began, the beginning of June, when we began the end of May, that's when we last tried to unlock and return to a more robust proceeding. And between the summer holidays, Memorial Day, 4th of July, and businesses and a lot of other activities trying to resume, you see the spike. And then you've seen people try to throttle it back down. But a concern is if we're at 40,000 cases, and now we unlock again in some fashion, as Liz described, we may just keep ratcheting ourselves up each time. This could look more like a stair with a little dip and then the next stair. And that's worrisome.
We have Labor Day coming up. What are we going to see around Labor Day holiday and all of those activities that we saw related to Memorial Day, and so some of the dropping of the precautions.
Correct. Well, let's talk a little bit about the challenge that we're facing, because while that trend is going on, and certainly, I mean, anyone I think that most of us talk to professionally or personally are very focused on that, Congress, unfortunately, has left Washington largely, although they came back the House did, for a special vote on Saturday. But largely, the political parties have returned to their respective efforts to nominate and conduct their political conventions, largely in a virtual manner. I'm sure many of us saw the Democratic convention last week, Republican convention starting today. But the upshot is, other than some attention on Postal Service, Washington, the congressional front, is largely shut down. And they left in a gridlock situation a couple weeks ago, with many, many people frustrated and surprised that there wasn't action taken. Earlier in August, on Saturday the 8th, President Trump, though, did engage in a number of actions unilaterally. Some accused him of political grandstanding. Others said, what's he supposed to do? He did the best he could because Congress wasn't getting anything done. So putting those issues aside, what we want to do is make sure that all of you are aware of what did the president do, because it does have some impact on what's going on. And he signed an executive order, and he signed 3 presidential memoranda, all of which to varying degrees did provide some relief and did address the COVID circumstances that we are facing in the workplace and more broadly. So Bert, let's turn, maybe you can kick off for us the beginning of those, what he did.
Yeah, there is, thank you, David. There is a kind of common theme, and the timing of the executive orders and the memoranda and the substance of them really indicate how the president can control the agenda, can control the stage, but that acting unilaterally doesn't really address the underlying issues. For example, the one executive order that was signed addressed or sought to address evictions, but the fact is it really doesn't. What the executive order did was order the Secretary of HHS and the head of CDC to consider whether action on evictions was needed. And the next half of the order was to ask the Secretary of Treasury and the Secretary of HUD to see if they could find funds to assist with the ending of the eviction moratorium. So the eviction ban did not end. It came to an end at the end of July. People there are something like 30 million renters who are facing possible eviction, especially those that have also lost their jobs. But this executive order merely asks that other members of the cabinet see if they can find a way to address the problem of evictions. And frankly, this was kind of surprising because of the federal role as essentially the guarantor for most mortgages in the United States. The president does have options to actually act to create a moratorium or to do something more, and chose not to. Whether this is to pressure Congress or whether he felt that would be a legal challenge, we don't know, but we do know that he did not take that action. The other memoranda are probably more widely known. The first had to do with the unemployment supplement. As you all know, the $600 supplement to unemployment benefits ended also at the end of July. Congress struggled for weeks, it seemed, certainly for hours, to try to find some middle ground. The Republicans came up with a $200 supplement. The Democrats rejected that. Somewhat oddly, the president kind of trumped his own caucus and proposed a $400 supplement. But $300 was going to be from the federal government and $100 was going to be coming from already cash-strapped states. That didn't last very long because most states said they were not about to do that. They didn't have any dough. So the current memorandum proposes a $300 unemployment compensation supplement. But it's not the same as the prior one because the source of the funds and the mechanism is different. It's going to be slower. The funds will be coming, oddly enough, they're going to be repurposed from the Disaster Relief Fund. And with the fires in California that we all see raging, the derecho that just about wiped out the corn crop in Iowa, the two hurricanes coming towards the Gulf Coast, you wonder just how those funds are going to be manifested. In the best of circumstances, at current unemployment rates, it is projected that the funds will be exhausted in 3 to 5 weeks. It's $44 billion. Some of that will certainly be earmarked for the newly declared disaster relief in California and for the coast. Also, there's a whole new mechanism that's needed to process the funds, and many states don't think they can get that going for a couple of weeks. So it remains to be seen whether this is a campaign pledge, because the president also said that if he's elected, he will do more on this front to try to get more money to everybody. The next, probably the most widely known, the one that got the most press, was the payroll tax deferral. The president has the authority and did say that he would defer the collection of the employee portion of the payroll tax until the end of the year. Highly controversial, opposed by most senators who face re-election because the payroll tax funds go to fund Social Security and Medicare, which are very popular programs, the so-called third rail of U.S. politics. But please remember, this is simply a deferral. And on January 1st, the bill comes due. And both a number of employers and employees are wary about this because, let's face it, if you get that dough in your pay packet, you probably have many needs. Rent, mortgage, we've heard about the eviction crisis. You've heard about the reduction on employment benefits. That money will likely be spent. And then what's going to happen on January 1st when the bill comes due?
One thing that I
Hold on
think
just a second.
yeah. as the unemployment funds are tapped into, there's a very uneven patch. Whereas before, when the $600 kicker went in, that was nationwide. Whereas this, as Bert indicated, different states, and at least when I checked on Friday, we still had less than 50% of the states that were interested in participating in this program. So if we look across the country, do we have this supplemental unemployment insurance? The answer is sort of. It's very uneven, and certain states have extremely low unemployment to begin with because it's designed not really to make people whole, but to incentivize, which means penalize someone if you're not working, and to give you so little that you really want to get out and find some job, do something to mitigate that situation. But that philosophy doesn't work quite as well in a pandemic economy where there's not necessarily work to find. Yeah, Bert, go ahead.
Over 20 states, they're starting to queue up, as it were, to join in because they want their citizens to get this dose. South Dakota has just flat out refused. But again, the issue is by the time the program gets up and running, will there be any dough? The last of the measures was a deferral of the collection of student loan interest, not the student loan. So people's interest payments for student loans will again be deferred to the end of the year, but the payments are still due, and come January 1st, those accrued interest payments are still due. So generally speaking, the president's efforts were an attempt to control the stage, especially during the period of the Democratic conventions, but there is widespread doubt that they will address the underlying problems. And it's an interesting balance. Was this an attempt to put pressure on Congress? From an external observer, the pressure on Congress is on his own party, since the Democrats want to do even more than the president has done. So that's one of the odd things that happens during these political convention periods and presidential election periods. Please, let's move on.
Well, yeah, let's go on, because preceding that, although those received a fair amount of attention, but earlier that same week, on August 3rd, the president issued another executive order directly focusing on the workplace. And this is interesting. It's sort of teeing off on the use of H-1B foreign workers. And I think that everyone on this call is familiar, and many of the organizations represented on this call are regular users of the H-1B workers and understand that workforce. What the president said in his executive order on August 3 was that they want to look at all contracts, all federal contracts that were issued in fiscal years 2018 and 2019. So this is looking back, pre-pandemic, to say what really went on in those contracts with respect to the use of H-1B workers. Specifically, they want to look at the use of the temporary hiring of foreign labor here in the U.S., primarily through the H-1B program. Additionally, they wanted to look at whether jobs were being offshored and taken outside the U.S., and to assess what the impact is. It's kind of an interesting concept, because largely the way the H-1B program was structured was to actually review on the front end, what is the impact on the American worker and the American workforce, and that is viewed as basically the H-1B program oversimplified is an employer has to demonstrate, I couldn't hire the skills that I need. I've tried in the American workforce, and I'm paying a market competitive wage, but I can't get the critical skills, let's say as a computer software engineer. Therefore, I need an H-1B worker to do this work. But and normally it's the Labor Department that administers that part of the program. Labor says, we agree. They review your paperwork on that. You're then authorized to hire the H-1B worker. Now the president says, okay, that's great. You did that 2 years ago and 3 years ago under your federal contracts. Well, but let's find out what was the impact on the U.S. workforce. Well, in theory, the Labor Department already knows that. He could have called Gene Scalia and said, give me the answer to that, and someone could have done that. But what the executive order says is by September 17th, that is in 45 days, the Secretaries of Labor and Homeland Security are to take action as appropriate to ensure that all employers of H-1B visas, including second-tier contractors, so not just primary, but second-tier contractors, are fully complying with the H-1B program. So you know what that means. After putting that type out, that means you can expect some stepped-up enforcement after that. Then later on this fall, by December 1, after the election, but for the last 8 weeks of the administration, each agency in the executive branch is to issue a report on how they have used foreign labor in their contracts, what jobs they have offshored, and very specific recommendations on how their future contracts are to be further amended to improve the lot for American workers. This is one that, I mean, honestly, it kind of in its nascent stage doesn't have that much. It's a very strong foundational element, and certainly in the event that the Trump administration receives a second term, I think this executive order will see lots of action in the U.S. workforce and workplace, and have lots of impact on that. So these are things that I think just in the fire hose of events get washed over, but are important and do tell us that these issues continue to be looked at pretty carefully and re-examining, quote, American work and how that's shared or not shared with foreign workers. All right. Well, that is more of an alert on perhaps future challenges, but what we have now is an immediate challenge, and that deals with what has been fairly widely reported, this decision. And normally, Liz, we'd say, what do we care? It's like one federal district judge. So why are we so worked up, and we are, about what happened with the relatively new regulations that the Labor Department issued under the FFCRA?
So let's lay some groundwork here. If you recall, when FFCRA first was issued, Department of Labor was directed to generate regulations providing clarity and assistance. And so there's the DOL final rule, which is what was subject to this review by the Southern District of New York. So there were 4 components of the DOL's final rule that were challenged in this court opinion. And essentially what the court was looking at is, did the DOL go beyond the black and white letters of the act in creating its implementing regulations? And we're going to talk about each one of these components in more detail, but it is essentially the definition of a healthcare provider under the DOL the final rule. The requirement of work availability for certain leave provisions, the availability of intermittent leave, and also the record requirements in order to take the leave under both the paid sick and the paid family. So the first one that we're going to talk about on the next slide in greater detail, and I think this is the piece that's getting most of the buzz, I think, here, is the FFCRA referenced healthcare providers as being exempt from being able to be provided leave. And the only statutory definition that was referenced by the FFCRA was that of the healthcare provider in the FMLA. The FMLA has a very narrow definition of who is a healthcare provider. The doctor of medicine, and the focus really is on providing healthcare services. Another part of the FMLA reg gives some examples: dentists, doctors. So really, are you providing those services, healthcare services? The DOL's final rule was a very expansive definition, and I think the first provision of it, employed at a doctor's office, gives you insight to how broad this definition really was, to the point where your night cleaning crew that never comes into contact with a patient could be considered a healthcare provider under the DOL's final rule. So the court said it was the DOL final rule was overly broad. They revoked that definition and took it back to the FMLA definition, which is really focused on those individuals who are capable of providing healthcare services. It's a pretty significant change. You have a large number of employee types that previously were exempted from leave that are now going to be eligible for leave because they no longer touch on that healthcare provider definition. And I just want to say, I'm going to go through each four of the components of the decision, and then we're going to turn it over to David and Bert to kind of talk about what does this really mean. So before we give you kind of the how do you do it, we're going to talk about that in a minute. So we're moving on. The next element of the opinion that was challenged was the DOL's requirement for the work availability requirement. This is on the next slide. Sorry. So another piece of this is the DOL's final rule added in an exemption that employees were not eligible for leave if the employer didn't have work for them to be doing. And they added this only in 3 of the 6 bases for getting emergency paid sick, and the only, the one reason for emergency family. And the Southern District of New York vacated that portion, saying there's nothing in the FFCRA that mandated there be work available for these individuals in order for them to be eligible for leave. They also looked at it and said the different treatment was unreasoned. So they threw that requirement out, that you don't have to show that you have available work in order for your employees to be eligible for the leave. So again, this is another basis that you may have denied an employee leave who actually is eligible under the FCCR. The next component of the opinion that was addressed by the court was the DOL's final rule included a provision that said intermittent leave is only allowed if the employer consents to it. So you can request intermittent leave, but it requires the employer to give you that permission. This was partially rejected, partially accepted. So here the court again said this goes beyond what the FCCRA contains. There's no requirement for employer permission, and there's no ban on intermittent leave in the FCCRA as drafted. However, the court did say, but this makes sense in certain instances. For example, if you have an employee who is out because they have COVID symptoms, they've been told to stay out by a doctor, obviously you do not want them coming back in intermittently, okay? That, the court said, makes sense. We're going to keep that piece. What the court did reject is the requiring employer permission, and here's a key piece and a kind of a theme of today's discussion. It used under the DOL's final rule to do intermittent leave, for example, when your children's schools are closed because you need to be able to be available for your family and for your children. Intermittent leave is only available if your employer consented to that, with the permission of the employer. So there's a lot of working parents who have children at home who were not allowed intermittent leave if their employer said, that's not really going to work for us. So the court has rejected that and vacated the requirement that the employer approve those intermittent leave. It's only at their approval. So that's another key point. And then the final element is the DOL's final rule was significantly differed than the FFCRA with regard to the required documentation in advance of leave. So for emergency family leave, the FFCRA said that employers could provide or can require notice as practicable when leave is foreseeable. Easy for me to say, huh? And then the emergency sick leave, the Act said the employer may require reasonable notice procedures, right? Thinking back on what's in place for your current sick leave, what's in place for current FMLA. The DOL final rule went a step beyond, and they require documentation be provided prior to taking leave. So again, the court vacated this ruling under a couple bases. First, beyond what the FFCRA requires, base language. The other thing that we are seeing, and especially at the initial stages of COVID, is employees not able to get this documentation. People were not able to get into the healthcare providers. If they were, it was a virtual thing. Then how do you get that documentation? There is just in addition to being beyond what the act required, it was just practically impossible a lot of times. So that's another piece of the court carved that back and said you no longer require notice in advance, and went back to the actual language for the practical notice and reasonable notification for the family leave, for the sick leave under the act. So now I've gone through those requirements, but what does this mean? And I want to turn this over, right? What do you do with this? And so I'm going to turn this over to Bert and David to talk through what are your next steps as an employer.
Sure. I'll take one or 2 points, and Bert, jump in. First is the scope, and I sort of alluded to this at the top of this discussion. This is one judge in the district court in New York, Southern District, New York. That's Manhattan. Many people might say, so what? With all due respect, that's just not something that we're care as much about. Well, we may care a little bit about it for several reasons. Number one, the party who brought this action was actually the state of New York. So it sets up that at least the state of New York. Number two, the reasoning that the judge has employed, parts of it are candidly fairly persuasive, and that many employers, many on this call, that have multi-state jurisdiction and multi-state operations don't really want to risk little pockets running one way or the other. I mean, if you run the local hardware store in a small city in Iowa, maybe you don't care as much about what this one federal judge did in Manhattan. Most of you on this call, that's not your operation. Multi-state, and it seems to me that the issue, even though as a lawyer I might make a nice distinction and be able to limit it, particularly since the Court of Appeals hasn't ruled on it, that maybe I should think more broadly and be conservative in how I handle this, and think about trying to ensure that the rest of my policies are aligned and take into account this ruling. Retroactive application, let me just say, Bert, I'm going to give to you.
Well, yeah.
I wouldn't worry as much about that.
There are a couple of things
myself.
Yeah. A couple of things. Also, let's not overlook the fact that the Southern District of New York is the home base for companies. New York still is the headquarters of most Fortune 500 companies, so they're right in the target zone for this decision, and they're going to be thinking nationally, as you pointed out. I don't think there's much concern about retroactive application. The court did not mention it. It is highly controversial. Only Congress can do it. Going forward is the big issue, and here's where the issues start piling up. The Department of Labor has not appealed this decision. So that opens the door to what is being planned. Are they planning a new?
To be fair,
here they're talking
the government has up to 60 days to make that decision. They've got till October, which doesn't help much in the circumstances we're in. But you're right. They haven't appealed.
They haven't appealed,
what his labor says,
which opens the door. It opens the door to, do they plan an interim final regulation to fix these holes, to try to make compliance easier? Are they, frankly, what we haven't mentioned, are they leaving this to Congress? Does everybody, should we anticipate that once the conventions are over, Congress gets back to work, or do we go into the presidential election mode, and if passed as prologue, Congress doesn't do much of anything during that period? So there are all kinds of questions about what the next steps are, either from the executive branch, the Department of Labor, or from Congress. As to the final step, the big question for me, and this, we don't like to get into the political realm, but the problems of all of the people being out of work, many losing medical care. The whole notion that the U.S. system of paid leave and sick leave seems to not provide the kind of safety net that was hoped for and was imagined. And so many people, millions and millions of people, are now in this situation.
Right.
That it's, it used to be only for the poor, only for the undeserving poor. That is no longer the case in the minds of millions of people. Please.
Let me turn to a specific question that I have for Liz. Under the new definition of healthcare provider, this narrower definition, does that definition include virtual appointments? That is a question from that we've received from someone in the audience. I think the answer would be yes. It doesn't matter where the work is performed, but
I think it is, and I think part of the issue there is the necessity to have that work available and that being performed. So that's the issue, is we need to be able to have our healthcare providers available to us, whether it's virtually or a doctor's appointment. If there's a lot going on in our world right now, but we can't lose access to our doctors. We can't lose access to healthcare. And so I would say that is the impetus of why. Because the other group of people who were exempted was first responders. So it's that same concept there, is we need that work being done.
Right. Well, let me just say, I think that we have a consensus among us, at least. Wouldn't worry about retroactive. I would be conservative. I would pay attention to this decision. I would make sure that your policies are aligned going forward. And there's at least some indication that we can anticipate the Labor Department will be issuing some further guidance reasonably soon. I don't think this is not going to be sorted out through the courts. The Labor Department, either through interim guidance or an interim regulation, maybe just addressing healthcare provider and some of those issues. But DOL, after 3 weeks of silence, I think we will hear from them very soon, which would be good. But in the meantime, I think that you would be well advised to trim your policies appropriately. All right. Well, let's look quickly at some of the other challenges that employers are facing in dealing with the changes in legal protections and how they're proceeding. Obviously, one of the constructs is that with Congress being gridlocked, what's going to happen? And Bert, you mentioned before that one of the key priorities for Senator McConnell and the Republicans, I don't know what the White House priorities are, but at least the Senate Republicans, that feels like a separate group almost, but their priority included safe harbors against a wide array of COVID-related claims and liabilities so that employers would be more comfortable and face fewer legal headwinds in trying to reopen and restart operations. But do you want to address a little bit about because that hasn't happened, as you mentioned. What's happened?
That hasn't happened. In fact, Congress proposed a very broad, sweeping kind of federal tort reform. It's almost a wish list of certain people in Congress. But the states aren't waiting. Many states, here just a list, the numbers are growing every day, of providing some protections for legal liability for employers who fear being sued both by workers and by customers. Some states like California have recognized that the real issue is workers' comp. I mean, it's the issues of proof of I got COVID after 20 minutes at the drugstore, if you're a customer, are kind of hard to imagine. But California simply said, forget it. If you have a rational claim that COVID was work-related, we're going to cover it with workers' comp. Workers' comp, remember, is a state-administered no-fault insurance policy. The employer is 100% protected. They pay for it every week in the paycheck. The money goes to a fund. Whether California's funds are going to hold up with all of these, remember the hundreds of, the million cases in California, remains to be seen. But this is a locus classicus of how the states are taking the actions because the federal government hasn't. But there is a problem. Without federal standards, it is increasingly difficult for a state to be, for an employer to be able to say, I did enough. And
right.
many,
and I'm going
congressmen
to talk about that.
Please.
I'm going to talk about that in a minute. I want to just point out that some of the states, though, as they are enacting these changes, for example, Tennessee, this shows the breadth of protection that employers are given. In Tennessee, this is a law passed last week. The new state safe harbor says that the plaintiff has to prove gross negligence or willful misconduct, as we note, and they have to include a signed statement from a medical doctor attesting the doctor's belief that the plaintiff's injury or sickness resulted from the defendant's action. So to Bert's point about the customer that goes in the store, they're going to have to find a doctor that they were there for 20 minutes and that is why they got sick, not because of something else that they did during their days there. All right.
Pandemic.
So this response to gridlock, nothing stays static. And if Congress does not act, the states are. And again, for multi-state employers, most of you are, very stark patchwork that's beginning to develop very, very quickly. Well, let's look at some other trends that we're seeing that I'm going to just touch quickly. As anticipated, there have been a beginning, what looks like the beginning of an uptick of WARN, that's the plant closing law. And the question is whether a WARN contains an exception for unforeseeable circumstances. Arguably last spring 2020, COVID was an unforeseeable circumstance. But as employers continue to move from temporary to permanent layoff, the growing question is that really unforeseeable? And I think that many well-counseled employers are including WARN, and we have previously addressed this in some detail in prior briefings. You should comply with WARN. You should think about it, provide the requisite notices to the workforce, the state agencies, and cover yourself so you don't get caught on that. Second, yes,
let me just also point out,
because we're very tight on time.
Many states have lifted their WARN laws, but that does not relieve you from federal WARN obligations.
Correct. Second, various state tort law claims and nuisances, and we'll go back and use Whole Foods as an example. Whole Foods faced Whole Foods, which is now owned by Amazon in New York, faced claims under state tort laws of nuisance, alleging that they had violated the state tort nuisance by failing to provide a safe workplace. And the response was, no, that is not it. And oh, by the way, you really should be filing an OSHA complaint. This falls under the OSHA general duty. The response from the plaintiffs was exactly what Bert highlighted. No, OSHA's not doing anything. The cop isn't on the beat, and their standards are so general that it doesn't help us anyhow. That's still being sorted out. And finally, OSHA itself, which not only investigates under the general duty, but deals with the Section 11C complaints, what are called whistleblower complaints under the OSHA Act, as well as retaliation. That is, if someone has filed a whistleblower claim or a claim recognized as a whistleblower claim, and adverse action occurs, whether they whistleblower, there's about a 400% to 500% plus explosion of those claims that are now, and OSHA gets to sort those out too, that OSHA's dealing with. So that is a growth area, and again, this is something that employers in many industries, many sectors, this isn't just manufacturing or healthcare, office settings, a wide range of industries are experiencing these growing number of claims. Okay, let's move on from there and talk a little bit about probably the biggest item where we are on the calendar is schools reopening. Liz.
Yeah. And the concept here, and there's a lot we could talk about here, but for today, I mean, we do a whole university series. We could spend time there, but the issue today is the uncertainty of schools and how it's impacting your workforce. So true economic recovery is not going to really happen and get traction until we know what's going on with schools, because this is impacting all of the parents out there, notably with K through 12, right? I mean, the college age kids, this is causing some demands on parents as well. I'm not diminishing that, but for the focus of today is really thinking about what is going on with the parents of K through 12. They need to be there for their kids. And Bert and David both touched on some of the decisions that are being left to the state about how they handle it, and there's some state laws. But I think the key thing for us to talk about right near, and we're a little short on time, is as an employer, what can you do, and what are some of the other employers out there doing? And I think both Citibank and Bank of America have gotten really out in front of this and have been very public with some of the efforts that they're doing for their employees. For example, they are both figuring out tools and mechanisms to get their employees discounts on educational tutors, test prep programs. They're going out and they're seeking those discounts for their employees. They're building online databases and groups so that if you want to pool your resources and get a tutor and build a pod, whether that's going to be a virtual tutor, or are you willing to do some home-based pod building type tech tools? Both Citibank and Bank of America are working with their employees to provide them support and resources to do that. They're also expanding their backup childcare funds. Bank of America is actually providing a daily child care stipend and I think the amount is being based on your compensation level. But there's a lot of extra benefits that are going to be being provided to those individuals, which I think is very beneficial and important. There's a little caveat that I have to be the negative Nelly occasionally on this, though. There is a discussion that some of the funds that used to go to the providing the cafeteria lunch to everybody, providing some of those benefits that used to go to the entire workforce, are now being funneled into these programs that are going to help parents of young children. No good deed goes unpunished, right? So we are also hearing a little bit of a back end from the individuals who don't have children or have children who are above the ages that this isn't necessary, the what about me component. So we're also hearing some of their employers are not letting up on some of the other benefits. Tech industry. There's one tech company just had a ukulele team building session where they sent everybody out ukulele kits. So, really, hey, I mean, I do at-home flower arranging classes. I haven't gotten Bert or David to do it with me yet, but I'm on a campaign, right?
I'm waiting. You haven't asked.
But I do think it's really important. I mean, I not diminishing the need to put these programs in place for your parents of small children, because they're the ones, that
Right.
is where the real hurt is. But think holistically and think about the other members of your workforce, and so that nobody feels disenfranchised or left behind.
Well, and Liz, these programs do fit into what people are quickly realizing when the recovery shapes up. Initially, is it going to be a V? Are we going to bottom out and bounce right back? No. Is it going to be the Nike swoosh where everything just sort of comes back, albeit more slowly? It doesn't appear to. There are now growing indicators that it's quite different than what people are describing as more of the K model, that the white collar professionals, those that can work virtually, are going to work and do well, relatively speaking.
Those who can afford these resources already without having the assistance, right?
Exactly.
So this is right.
Right, but then you have those that need to come back, and they're faced with, whether they be restaurants, lodging, and a host of other industries that are being forced. They cannot work virtually, and that disproportionately affects persons of color and women. And when you add on the school challenges, that makes it much more pronounced. So this is an issue that kind of weaves into and is intertwined, I think, with the Black Lives Matter issues, and there have been some developments there that we want to touch on. And Bert, I'm going to ask you if you can hit those.
Be happy to do so. If we could go to the next slide. We knew this would happen. This is an election year, and we're now getting issues in the workplace about what constitutes political speech, what constitutes irritating speech, what constitutes disruptive speech. Let me start with the tradition. The traditional rule is that an employer and employers have routinely barred political messaging, period. Remember, the First Amendment covers Congress. It doesn't cover a private sector employer. And traditionally, employers have said, we don't want these things in our workplace. We don't want disruptive messaging. No hats, no pins, no posters, no political posters. Well, traditional rules have been breached over the past several years, and they're coming to fore here. Whole Foods, oddly enough, an Amazon-owned company, was one of the companies that barred Black Lives Matter masks on the grounds that it constituted political speech. The backlash there, of course, was no, it's not partisan, it's not political, except with a capital P. It's not about one party or the other. So that dispute is still going. Everybody knows about the Goodyear MAGA hat ban and the enormous backlash from Ohio, from Akron, from Goodyear, when the president suggested that people should boycott Goodyear because they banned the MAGA hat. Please remember that the National Labor Relations Board, which is the body that talks about workplace speech most, has over the past year made it clearer and clearer that an employer has the right to have rules about civility and about conduct and about speech in the workplace. And those rules will probably proliferate over the coming months as we get into the election more and more. And this also, everyone should take this opportunity to think about the kinds of passions that yield to these events and think about the kinds of training, the kind of messaging that the employer can give with respect to the bias training is just one, but there are a whole range of training policies that an employer can undertake to try to lower the emotional temperature, which is going to go higher and higher in the ensuing months.
Right.
Let's move
on.
So
policies of neutrality, policies of neutrality, and also I think that recognizing it isn't just the physical workplace, it is the virtual workplace where these same points are considered. How people present when they're on video, which is a very common way of interacting today. Are they wearing logos, hats, etc.? What statements are made? So this point about the training, recognizing the NLRB's very positive decision in General Motors that allows the employer to frankly regain control in the workplace. Mm-hmm. Paying attention to that Whole Foods case, which attempts to use Title VII, saying you selectively enforced the policy, even though you were neutral, you selectively enforced and tried to violate Title VII. So I don't think that's going to work, that claim, but that's what's being asserted. So that's there. All right. Well, let's talk about the agencies because they also have continued to be reasonably busy and keeping a pace. So let's start. Liz, you want to start first on EEOC because rulemaking is fairly unusual for EEOC, and they're doing one.
We believe, right? Yeah. So on August 18th, EEOC held a public meeting to discuss a notice of proposed rulemaking that is imminent, and we expect that it is going to contain some substantive changes to the Commission's EEOC process. We don't have the full details yet of what's going to be in the notice of proposed rulemaking. We do know that its aim is to enhance the effectiveness and to create accountability and transparency in the existing conciliation process. During the meeting, it was shared that this was the result of several years of discussion regarding their conciliation process, and the finding that only 40% of the cases that have a for-cause finding actually end up with a successful conciliation. So the Commission is looking at this. And again, what we expect to see in it, briefly, increased transparency, and some of the concepts we think we're going to see is identifying who has participated in the investigation, a summary of the facts that they found in that investigation, as well as factual and legal support for their findings. and potentially an opportunity for the respondent to reply to the information provided in the conciliation. So that is going to be very substantive modifications. So, and then once the notice of proposed rulemaking comes out, it'll go through the notice and comment procedure. So I'm looking forward to seeing that, and we'll hopefully see it soon.
Be very welcome. EEOC has historically received very strong judicial criticism and been sanctioned by the courts for its failure to conciliate in good faith. So it would be great to have that rule. And frankly, it'd be great to see other agencies, particularly I can think of some maybe at the Labor Department that might want to consider a similar rulemaking, but that's a different day.
Indeed.
Bert, nominees. Do we still have any? What's going on?
The NLRB is done. There are 3 Republicans and 1 Democrat. Not the usual mix, but there is no Democratic nominee. The EEOC, we're still kind of in limbo. Keith Sonderling and Constance Burrows were confirmed, nominated and confirmed. Joyce Samuels is still hanging. She is held up probably by the Freedom Caucus because of her LGBT background. But the EEOC will continue to function. Commissioner Lipnick will stay on board, but they won't have the full nominating board, as it were, and that is still pending before Congress, and it remains to be seen what they will do, whether she'll stay in the mix, whether the nomination will be withdrawn. It's hard to know.
I think the practical problem,
affirmative action?
Yeah, if they can't agree on the COVID, it's hard to imagine them getting down to the EEOC nominees. But
True.
Yes. So the Trump administration has shown over the last couple of weeks a couple of interesting developments we wanted to highlight for you, kind of rethinking, reimagining how affirmative action might be used. And specifically, the administration has in 2 instances taken, if you will, pardon the pun, affirmative steps to raise the issue of whether affirmative action is unfairly impacting whites. And that occurred in 2 settings. First was the Justice Department wrote a letter to Yale University. And the way the Justice Department works, they write you a letter and basically say, look, we think that there's a legal violation and we're going to give you 1 chance to fix it. And if you don't fix it, we're going to sue you. In this case, the Justice Department's letter said to Yale, we think that whites and Asians have a much smaller chance of being admitted than others. And we think, therefore, you are suppressing whites and Asians' applications to favor non-white, non-Asian, so Black, Hispanic, and other protected groups admission unfairly, and you should not be taking race into account. Bert.
Yeah, well, the interesting thing is, this was a suit against Harvard on these very same grounds that lost in the district court. So you have to consider that this is you might consider this is a political rather than a judicial step.
Well, and the Justice Department intervened in the Harvard case. They are going up to the First Circuit. The Justice Department has now put a marker down for Yale. And the same litigants that brought the Harvard case have also sued University of North Carolina and in Texas over the last 2 weeks. So this issue, if you're looking at the circuits, they are looking to, if possible, create a circuit split and get the Supreme Court to weigh in on this. It could make Bakke and Weber and some of these other cases very much in question when this is done. Second, under Executive Order 11246, the Labor Department held a contractor, said that they had violated 11246 because they failed to have an affirmative action program to benefit whites and males. And this, I will say, was rather shocking. The order's been in place for 55 years. I don't think it's ever been viewed in that way. Their regulations define the protected groups. They do not include whites. So that is another indicator. Finally, as of this morning, we just want to quickly hit this for you. The Wage Hour Division issued a field operation bulletin addressing how for teleworkers and people that are working remotely, and these are obviously non-exempts, how you keep track of time. And I would encourage you, it's readily available on the website. Having reviewed it, basically it puts a premium on employers having a well-communicated timekeeping system, having people follow the system, and paying for the time that people put in the system. So that's a very significant point and very helpful guidance that the Labor Department has issued. Let's real quickly, because we've got about a minute left. Valerie, hit the last slide on some key takeaways.
Well, I guess let me start with the one where we started. What's going to happen after the conventions? Will Congress get back to work, or will they hit the campaign trail? Can they resolve their issues? Will they be split further by the party platforms? And in response, we're seeing states are taking action in a number of areas to fill in the gaps that Congress has left, but there are certain things that only the federal government can do, and we're all waiting to see if they will do so.
Liz?
Assess those COVID policies. See if you have policies that prohibit intermittent leave without permission, your definitions. Look at how you're applying, responding to requests for leave. Also, be careful if you have somebody who reapplies who was previously denied. Do not rely on a prior denial to support a current denial. Apply the current standards to see if they need to be granted leave at this point in time.
Good point. And keep an eye out, because we think the Labor Department's going to issue some guidance on that. With respect to the school openings, particularly, this is a major part in bringing people back to work. Be attentive to that. And this dovetails right back into the point that Liz talked about qualifying for paid leave, and also about how you shape your policies and what you're going to do to be competitive. A number of employers are finding that unless they respond to this reality, they are going to lose key talented members of their workforce. And so be thoughtful about how you respond to that challenge. Bert, I'm going to give you the final word.
Finally, for both employers and employees, this radically divided society we're in the midst of an election campaign, for employers, do what you can to create policies and training to lower the emotional temperature. Remember that you're empowered by the NLRB to issue conduct and civility rules, enforce them uniformly, consistently, and you possibly have a leg up of keeping your place calmer than it might otherwise be. But it won't be calm.
Terrific.
It's going to be a hell of a ride.
Thank you. Thank you, Bert. All right. So I want to thank everyone. We're next going to get together, hopefully with all of you out there, on September 21st. Events suggested we will have more than 60 minutes worth of material to cover at that time, but we're really looking forward to it. So I want to thank everyone, the presenters, and most importantly, those that joined us virtually, for taking time to join us today. Thank you, Valerie.
We would like to thank you for joining us. As a reminder, all registrants from today have been registered for future briefings, and you may view this briefing as well as our previous COVID-19 briefings on our website at www.FortneyScott.com. The next briefing will be September 21st. Please be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey, and of course, if you have any questions, you may submit them via email to info@FortneyScott.com.